Thank you. I'd like to thank Nan and all those who helped her plan this program. I think it's wonderful. The Senator's remarks were certainly educational, enlightening. It's nice to know that he feels as strongly about these things as we do at Labor, and certainly I think as many of you in the room do, and certainly as Alliance for Justice does. There's no question that the Supreme Court grabs all of the headlines, justifiably so. It addresses the social issues of the day, creates social issues where none may exist. But for many of us, much of what affects us occurs in the courts of appeals. The Supreme Court hears or actually writes about 80 to 90 opinions per year, sometimes less, sometimes more, while the courts of appeals, for almost any one-year period that you would look at, as reported on the federal judiciary website, hears almost 6,000 employment-related cases, 6,000 civil rights cases, about 1,000, 1,500 of those are classified directly as employment. The others are general civil rights, and another 1,000 or so cases that they classify as labor cases. So all told, 7,000 cases at any given time are pending before the courts of appeals. Who sits on those courts of appeals, of course, matters greatly. The Senator referred to this, but when I went to law school, I guess I rather naively believed that the courts and the judges would give any party a fair hearing, and that it really didn't matter who selected them, that once they sat on the bench, there was some kind of magical aura that surrounded them, and that they would hear our arguments and weigh them, and certainly if we had the law and the facts on our side, the case would go our way. Well, I had a Reagan appointee in a district court teach me very quickly that I was wrong. In an injunction case on behalf of a union, he took a year to decide it. We were seeking a temporary restraining order at the time. And when we did get our opinion after much begging, pleading, and even a sort of veiled threat that we would go to the Fifth Circuit, like that was a real threat, he issued an opinion that mirrored almost word for word a district court decision that had been issued in 1969 and which had been subsequently overruled by the Supreme Court. So I learned my lesson. But sometimes I wonder if those who are involved in the confirmation of judges and the selection of judges, and I'm not talking about just certainly White House counsel or senators, but all of us in the broader community who are involved in trying to recruit nominees understand just how important it is to have good judges. President Reagan, the two Bushes, they seemed to get that in order to advance their agenda, they needed to recruit folks and make sure they got confirmed. They put 187 judges in the federal courts of appeals. President Clinton got 62, President Obama so far 17. So just looking at those numbers and understanding, of course, that the Johnson appointees and the Kennedy appointees are largely gone or maybe sitting in senior status, the courts of appeals are pretty well stacked with Republican appointees. Now, keeping in mind what I said a moment ago, that these folks are there for a reason, and noting that, for example, a former Chief Justice of the Sixth Circuit said that in most cases the court could be collegial and get along, but when a labor and employment case came along, a new level of contentiousness seemed to exist between the judges. That was the Sixth Circuit, which is known for being contentious over anything that comes before it anyhow. And we found that. We have found that in every study we've done. If you're following the news and watching the events in Wisconsin, Ohio, elsewhere, certainly you understand that collective bargaining is very important to us. And obviously, we think very important to the country. Public opinion polls repeatedly show, even conservative opinion polls show, that the country at large supports collective bargaining for workers. And in fact, the National Labor Relations Act, which governs so much of what unions do, in Section 1 states that it's the national policy of the United States to promote collective bargaining. Now, that gets forgotten quite a bit, particularly by the courts of appeals. the way our process works, and the traditional way that we come about as the recognized representative of workers, is that we have to go to the National Labor Relations Board, which issues a decision. There's a hearing before an administrative law judge. There are elections whereby we get selected by a majority of the workers. And then any appeal from a labor board decision goes directly to the federal courts of appeals. Well, you can imagine, and the labor board is made up of political appointees, advice and consent of the Senate. So you can imagine that during the George W. Bush years, 2001, 2008, we did not have a friendly labor board. In fact, from labor's perspective, we had the most anti-worker, anti-union labor board in the history of the National Labor Relations Board, which dates back to 1935. So bad that in 2007, the last day of September 2007, labor refers to as the September Massacre. Approximately 50 decisions issued that day that significantly rolled back worker rights, union rights, going so far even as to going back to the very first decision of the National Labor Relations Board issued in 1935 to overrule the manner in which back pay for workers is calculated. Even with that, we were able to win, unions and workers were able to win 109 cases before that National Labor Relations Board. No small feat. We studied what happened to those cases when they went to the courts of appeals. Employers appealed. 75 of those cases were overturned by judges in opinions that were authored by Republican majorities. Another 20 were overruled by panels where the Republican judge was the author. So you might say, well, what's the impact? The union loses, big deal. Well, the impact really is this, that election campaigns, 24 elections that had been won by unions were overturned. Now that doesn't sound like much, but you have to understand that workers sometimes take years to come together to develop the common thought, the common issues around which they rally in order to decide that they want to be represented by a union. And to overrule an election sometimes 2 and 3 years after is effectively to kill that organizing campaign and, not surprisingly, on behalf of corporate interests, to hurt organized labor. Employers were permitted to unilaterally withdraw recognition from unions in 14 of those cases, meaning without an election of its workers to simply walk away from the unions. In several cases, employers were found to have lawfully refused to bargain at newly acquired facilities. They were allowed to discharge, discipline workers who were engaged in union activity. Scores and scores of workers, strikers who had engaged in concerted activity and were denied unlawfully by reinstatement by their employers were barred from reemployment. Now, it's not a coincidence. I could go on and on and on that these decisions come down the way they do. Given the makeup of the judiciary, given the corporate bent of these judges, there's no question that they understand just how difficult it is for workers to make this decision to organize a union, and that by forming a union, there are political consequences, as we are now seeing in Wisconsin, where those of us who are watching it closely believe that not only is it a blow being attempted blow at labor, but also a blow at labor's influence in the Democratic Party and an attempt to influence the Democratic Party's ability to be a strong party going forward. So I want to thank you for your attention. Again, thank you, Nan, and turn it over to Jeffrey.